Hi folks, my name is Darius Foster and I'm a Business Engagement Specialist in the Seattle Office of Labor Standards. I'll serve as a facilitator for this recorded webinar. This webinar is approximately 10 minutes long and it's designed to provide you with a general overview of Seattle's Fair Chance Employment Ordinance. The primary objectives for this webinar training is to ensure employers are 1. Aware of their obligations under the law, and 2. Understand key compliance requirements. Before we dive in, here's a brief timeline of Seattle labor standards and the Office of Labor Standards. Between 2012 and 2015, Seattle passed a total of 4 labor laws. The first labor law Seattle passed was the Paid Sick and Safe Time Ordinance in 2012. At that time, Seattle was only the 4th jurisdiction in the country to pass such a law, and the Seattle Office for Civil Rights enforced the law. In 2014, Seattle City Council passed legislation creating the Seattle Office of Labor Standards to implement and enforce the city's labor laws. From the periods of 2016 to 2018, Seattle passed 3 additional labor laws. And to date, the city has 7 labor laws in effect. In addition to fair chance employment, this includes minimum wage theft, secure scheduling, domestic workers, and commuter benefits. The mission of the Office of Labor Standards is grounded in advancing workplace equity. This is done by advancing labor standards through thoughtful community and business engagement, strategic enforcement, and innovative policy development with a commitment to race and social justice. OLS offers a range of services to support workers and employers. These private and free services include labor standards investigations, outreach and education, compliance assistance, and resources and referrals. For direct support, employers can contact us in one of 3 ways. By phone at 206-256-5297, by email at business.laborstandards@seattle.gov, or by sending us a message through our online intake form. It's important to highlight a key provision in each labor standard, the notice and posting requirement of the 11/17 Seattle Labor Standards Workplace Poster provided by the Office of Labor Standards. One important note, this poster is revised annually and employers are expected to have the most current poster. Employers must also display this poster in a conspicuous and accessible location where employees work, in English and in the primary languages of the employees at the workplace. Most employers are covered by 1 or more of the 4 labor standards on this standard 11/17 workplace poster. The smaller 8.5/11 secure scheduling workplace poster only applies to certain employers. What is Seattle's Fair Chance Employment Ordinance, or FCE? Well, FCE limits the ways employers can use conviction and arrest records for hiring and employment decision for employees working at least 50% of their time in Seattle, with the end goal being increased employment opportunities will reduce recidivism, reduce racial disparities in the criminal justice system, and strengthen our communities. Who does FCE apply to? FCE applies to employers with 1 or more employees working inside Seattle city limits, employee positions within Seattle, regardless of the location of the employer, corporation, or headquarters, job applicants, and candidates. The ordinance does not apply to individuals whose job duties or prospective job duties include law enforcement, policing, crime prevention, security, criminal justice, or private investigation services. Additionally, the law does not apply to individuals who will or may have unsupervised access to the following individuals during the course of their employment: children under 16 years of age, individuals with developmental disabilities, or vulnerable adults. FCE compliance requirements consist of the following 5 provisions of the law. Number 1, no job ads that prohibit conviction or arrest records. Number 2, no job application with questions about convictions and arrest records until after an initial screening is conducted. Number 3, no background checks until after the employer screens an applicant for minimum qualifications. Number 4, before denying a job based solely on the background check, an employer must provide an applicant the opportunity to explain and or correct conviction or arrest records. And number 5, an employer must have a legitimate business reason to support denial of a job. Job postings for work to be performed within Seattle cannot automatically or categorically exclude individuals with an arrest or conviction record. Examples of statements that convey categorical exclusions include, but are not limited to, felons need not apply, no criminal background, must pass background check, must successfully clear background check, must have clean criminal record, or must have clean driving record. Here's an example of 2 model statements employers can choose to include in job postings that is in compliance with the law. Model statement number 1. Hiring process involves background check regarding conviction and arrest records in compliance with Seattle's Fair Chance Employment Ordinance SMC 1417. Applicants will be provided an opportunity to explain or correct background information. Model statement 2. Job offer is contingent upon review of driving records subject to compliance with Seattle's Fair Chance Employment Ordinance SMC 1417 regarding use of conviction and arrest records in employment decisions. Job applications. Employers are not permitted under Fair Chance Employment to ask questions about convictions and arrest records on job applications unless the employer has already screened the applicant for minimum qualifications. Additionally, employers must delay background checks until after an initial screening. An initial screening is a review of an applicant's qualifications to ensure that that applicant possesses the minimum qualifications that are necessary for the job. Before taking any adverse action based on the conduct relating to an arrest, a conviction, or a pending criminal charge, the employer should let the applicant or employee know the information they are relying on. Additionally, employers must hold open the position for a minimum of 2 business days and give the person a reasonable opportunity to explain or correct that information. The ordinance requires employers consider certain factors to determine whether there's a legitimate business reason for rejecting an applicant or taking an adverse action against an employee due to criminal history, pending criminal charges, or conduct relating to an arrest. A legitimate business reason exists if the employer, after considering the following factors, believes in good faith that the criminal conduct underlying a conviction or charge will either have a negative impact on the employee's or applicant's fitness or ability to perform the position sought or held, or harm or cause injury to people, property, or business assets. The factors that the employer must consider are as follows: the seriousness of a crime, number and types of convictions or pending charges, time that has elapsed since conviction or pending charges, excluding periods of incarceration, verifiable information, specific duties and responsibilities of the position, and place and manner in which the position will be performed. How does an employer show that a legitimate business reason exists? Well, it depends on the specific factors and circumstances. In an investigation, OLS's assessment would be based on the totality of the circumstances for the specific case. An employer should document all actions taken and why they were taken. Employers should retain all documents related to the hiring process, including notes from the interview, job description, applications, and information provided by the applicants. Retaliation under the Fair Chance Employment Ordinance is illegal. Employers are prohibited from taking any adverse action or discriminating against employees who assert in good faith rights protected by the Fce Ordinance. These rights include, but are not limited to, informing an employer, union, or legal counsel about alleged Fce violations, filing a complaint about alleged Fce violations, participating in an investigation of alleged Fce violations, and informing other employees of their rights under Fce. The Fair Chance Employment Ordinance does not impact existing state and federal laws relating to criminal records in the event of a conflict where state and federal requirements supersede the requirements of the Seattle Ordinance. However, where there is no conflict and the Seattle Ordinance adds more protections than the state and federal requirements, the Seattle Ordinance takes precedence and employers must follow those additional requirements. For additional information, visit the Fair Chance Employment webpage. Scroll down to the resource section, and here you'll find material to assist you with compliance. For more personalized assistance, contact us directly. We can be reached by phone at 206-256-5297, by email at business.laborstandards@seattle.gov, or you can send us a link through our online intake form. Folks, this concludes the webinar on Seattle's Fair Chance Employment. I hope you found the information useful. Thank you for your time and enjoy the rest of your day.